Hi, this is Joe Gailey, and I want to welcome you to another installment of our educational webcast on the subject, Your Business and Your Employees, What are Your Obligations? Today we're going to be talking about retaliation. Now, all of these federal statutes that we've talked about in prior installments all carry a prohibition that you cannot retaliate against an employee for making a complaint or reporting the harassment. And sometimes this becomes a big problem for the employer. It's not unusual for the employer to be found not guilty of the underlying harassment charge, but be found guilty of the retaliation. Now, let me give you some very common types of retaliation that might occur that you need to know about. Let's take an example where an employee complains to their manager that their paycheck isn't right, that they haven't been paid all the hours that they worked. And the next thing you know, the manager has reduced that employee's hours. Well, that's a form of retaliation. That is a punishment inflicted on the employee for filing a complaint. And maybe you as the owner of the business didn't know anything about it. Doesn't matter. You're still responsible. So you have to have ways to prevent that. Of course, retaliation in its truest form is just firing somebody. Somebody comes and makes a complaint, say, about a hostile work environment, and you say, well, if you don't like working here, you're terminated. That is retaliation, and the law forbids that. And that opens up you and your business both for damages, not just for the lost wages, but for punitive damages. And the more egregious the situation, the higher the risk of punitive damages. This retaliation claim is by far the easiest claim to get to a jury. In the Northern District of Georgia, in federal court, some 90% of all of the claims, employment-related claims, are resolved in favor of the employer, except for retaliation. And many of them are sent to trial. So you have to be particularly concerned with this, because if it goes to trial, it's going to cost you a lot of money. You have to pay not only your own attorney fees, but also the attorney fees of the prevailing plaintiff, that is the aggrieved employee. Now, to give you a for instance, I'm familiar with a case here in the Atlanta area where the employee received $6,000 in damages, but the attorney fees were $178,000 that the employee had to pay. So many times the attorney fees are far more punitive in nature than the actual damages themselves. And of course, you as the employer would not only have to pay the prevailing party's attorney fees, you've got to pay your own attorney fees, which presumably would be the same thing or close to it. So this is not something to look lightly on. This kind of a claim can destroy your business, and it's not something that you can just not plan for. You've got to take some affirmative steps to set out policies and procedures in your business that will help minimize the risk to you. The best thing you can do to minimize the risk for retaliation is very simple. Treat all employees the same. If you fire one employee for telling an off-color joke, you fire all employees for telling an off-color joke. If you fire one employee for rolling back time on employees, you fire all employees that you catch rolling back time. Because any time that you show unequal application of your policies, you open up the possibility of being charged with retaliation. And you're having to go to trial, resulting in significant time, trouble, and more importantly, legal fees. I want to thank you for turning into this installment, and I want to encourage you to turn into the others that will be coming. Have a great day.